Hi, good morning. Thanks so much for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful and incredible Alex Barthet, a Florida construction lien law expert. Today's webinar topic is your lien is worthless on tenant buildouts, and here's why. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board-certified construction attorney here in Florida, and today we're going to talk about why your lien is probably worthless when you do tenant build-out work. So before we start, to the extent you have any questions, go ahead and submit them on the GoToWebinar chat box, which should be on your screen. Please do not include any names of people or companies in your questions, and we will answer all the questions at the very end. All right, so what are we going to cover today? Well, we're going to talk about why your lien on tenant build-out work is probably worthless. We'll talk about the lease agreement and why that is an important component associated with whether or not you have lien rights or not. We'll talk about the Florida law when it comes to tenant build-out work. And then most importantly, we'll talk about different ways that you can protect yourself when you have to do tenant build-out work. And of course, we'll answer any questions at the end. Okay, so why is your lien on tenant build-out work worthless? Well, you have to understand that your lien only attaches to the interest of the party that has the contract with the prime contract. So when again, whether you're a supplier or a sub or the GC, it doesn't matter. When that prime contract, the contract between the owner, quote unquote, and the general contractor is between the owner that owns the property. So if I own my house and you do work on it and you record a lien, your lien attaches to my interest in the property. And if I own the property, then that's the interest that you attach. But if you do work on a tenant's piece of property, so think a restaurant in a strip mall, a shoe store, a grocery store in a mall, that interest of the party that is hiring the contractor is the tenant. So you only have a lien that attaches to the interest of the party that has the contract with the general contractor. So if the landlord hires you to re-roof the entire strip mall, then if you don't get paid and you record a lien, your lien would be on the landlord's interest, right? So the property as a whole, right? The dirt. But if every parcel in a strip mall was separate and you service the air conditioner for the tenant, well, that unfortunately only gives you a lien on the tenant's interest in the property. So how do you determine who is the owner of the property? Well, you can go into the public records in the county where the property is located and do a search by the address. So what you want to do is you want to go to the property appraiser's website, type in the address, and it will tell you who the owner is. And if the owner of the property and the party that has contracted to do the work are not the same, then that's when the red flag should start to go, should start to wave, because now you know you have a bit of a problem. Some people incorrectly perceive that if the owner is listed on the notice of commencement, that therefore you will have a lien, an interest in the property if you lien. And that is not true. Sometimes we see the tenant has the contract with the general contractor. The county requires that the owner sign the notice of commencement. So you look at the notice of commencement, you see that the owner has signed it. That by itself does not create lien rights for you if the landlord has done all the other steps needed in order to protect their property and keep it free and clear of liens. And we're going to talk about what those steps are now. So how does a landlord protect its property and keep it free and clear of liens? Well, it's a multi-step process. So first, the landlord needs to include in their lease a provision that prohibits the tenant from recording any liens on the property. This is a very standard provision in most commercial and even many residential leases. Then a copy of that no-lien prohibition, either the whole lease or just that section, gets recorded in the public record. And the purpose of recording it in the public record is to let the world know that, hey, this landlord has included a provision in its leases for all of these properties that no one can record a lien on the property. So what does this mean if you do work on a leasehold interest and you don't get paid? You cannot sell the property, okay? So that means in a normal foreclosure, when you don't get paid, you sell the property, and if there's any equity in the property, you will get paid from that equity at the public sale. Unfortunately, when you lien a leasehold, which is permitted, and if you foreclose on the leasehold, then you get to move in and pay rent to the landlord, right? Because what are you taking ownership of? You're not taking ownership of the property, you're taking ownership of the lease. And the lease gives you the right to occupy and pay rent. Clearly not what you were hoping to do. Now, unfortunately, what we find is that when a tenant is unable to pay for construction, they usually are not able to pay for rent. So what happens is that in the course of the project fizzling out, they stop paying rent and the landlord evicts them. If the eviction happens, then guess what? You have a lien on a lease that has now disappeared because the tenant is no longer making lease payments and is in breach of the lease and has likely been evicted. So you have a security interest in what could be nothing, which goes back to the title of the presentation. If you have a lien on a leasehold interest, you may have a lien in nothing. Now, the reality is that this interest in the leasehold interest, or the lien in the leasehold interest, may be worth more than nothing, and it really depends on who the tenant is. So if you are building out a single location frozen yogurt store in a small strip mall, the likelihood of things going wrong if you don't get paid and having no security interest in the lease is very high, right? However, larger regional or national tenants like a national shoe store, a national restaurant, a regional furniture store, they're not likely going to let their lease go if you record your lien. So having a lien on a leasehold on a larger corporate tenant is probably worth something. It's not as good as having a lien on the actual dirt, the real estate, but it's not worth nothing. So let's take a quick look at what Florida law says on this. So the governing statute is chapter 713.10. And it says that if the lease prohibits the liens and notice of that prohibition is recorded in the public record, before the notice of commencement is recorded, it needs to include, and by the way, this is the information that you will be able to find in the public record: the name of the lessor, the landlord, a description of the property, and a copy of the language that's contained in the lease. That's what you're going to find in the public record. So if you're concerned about this, what you're going to do is you're going to do a search in the public record, first by the address to see who the landlord is. Then you're going to take that landlord name and you're going to search the public records and the recorded documents to see if anyone has recorded this lien prohibition. So the question is, okay, Alex, this is all well and good. I understand the problem, but what can I do to actually deal with it? So number one, before you sign the contract to do the work, you want to know whether or not the party that hired the contractor is the owner of the property or the tenant, right? So the first step is understanding, is your lien, if you record one, going to be on the dirt or just on the lease? Again, more likely than not, if you typically do tenant build out work, so you do mill work for restaurants and furniture stores, if you're doing work in a mall for a tenant, more likely than not that work is going to be directed by the tenant, and your lien is only going to be for the tenant's interest in the property. We talked about doing a search in the public records to figure out who the owner is and verifying if the owner is the one that hired the contractor, and if there is in fact a recorded no-lien affidavit in the public records. In our experience, almost always you will find that a landlord has followed these steps, and you will not be able to avoid the fact that maybe the landlord has missed something, so that if they didn't, for example, record a copy of the lien prohibition, then maybe you could still have a lien on the landlord's interest. That is highly unlikely. I've been doing this for about 25 years. It's only happened ever to me once where a landlord has messed up this process, and our client was lucky enough to get a lien on the landlord's interest because of that screw up. As a subcontractor, there are a couple of other things to keep in mind. You want to make sure that you avoid the pay when paid clause on work if you can, because now you have a double whammy, right? So if I'm a sub, let's say I'm the plumber and I get hired by the GC who is doing the tenant build out work, I realize now that my lien is not really worth very much because my lien is only on the tenant's interest in the property. Now, if I sign a contract with the general contractor and that contract has a pay when paid provision in it, then what security do I actually have? I don't have a very good lien. So if the owner doesn't pay, or the tenant doesn't pay the contractor, and I have to lien, my lien is iffy at best. But if the tenant doesn't pay the contractor and I have a pay when paid provision in that contract with the prime contractor, then I don't have recourse against the contractor, because under Florida law, pay when paid provisions are valid and enforceable. And as a result, if the tenant doesn't pay the contractor doesn't have to pay me. So I don't have a great lien. I have no right to go after the contractor. I really don't have a lot of security. Now, again, that being said, it's not that you don't have any security. So you still need to make sure that whatever rights you have, you can protect them. So you need to timely serve your notice to owner and record your lien. And then just make sure that you limit your credit risk associated with the work that you do, because now, unlike other jobs maybe where you would say, I'm willing to extend more credit because I have the ability to record a lien, and if I don't get paid, I can lien the job. That again is not of great value when you're just doing tenant build out work. Now, if there is a process that you can employ that's set forth in the statute, and that is, you can demand that the tenant and the landlord send you a copy of the lease, so that you can see what is contained in the lease. This is a document that cannot be sent with the notice to owner. And so you send your notice to owner, and then separately you send this demand for copy of the lease prohibiting liens. It's a statutory form, and if the landlord fails to send you a copy of their lease, it doesn't guarantee that they become liable. in case you don't get paid, but it increases the possibility that you can make a claim against the landlord and that your lien may attach to the landlord's interest in the property. Here's a copy of what this notice looks like. It is sent to the lessor, the landlord, and you include all of this information, including the warning. So the warning is really what triggers what you need to do. So it says, warning, your failure to serve the requested verified copy within 30 days or the service of a false copy may result in your property being subject to the claim of lien of the person requesting the verified copy. And what you're requesting is a verified copy of the lease agreement and the lien prohibition. So by sending this document as part of your process when you do tenant build-out work, you can potentially create a right to lien the landlord's interest if they don't timely respond to this request. So keep that in mind as something to use in your process if you want to try to create some more leverage for yourself. The statute, while it may give you the right to extend your lien beyond the tenant and extend it to the landlord, the law says that the contractor or the lienor must otherwise have complied with this part, which is the lien statute, and you do not have actual notice that the interest of the lessor was not subject to the lien for the improvements made by the lessee. Again, so that's why I'm saying it's not guaranteed that just by sending this notice and them not responding gives you lien rights in the property, but it gives you the possibility to argue that maybe that lien, your lien, extends to the landlord's interest. Now, SunRay has these forms that you can use, and they will prepare them and send them for you. If you wanted to just get the form for free, you can go to the lienzone.com/forms. We have this form that you can download for free and use as you see fit. All right, so to recap, be aware that when you do tenant build-out work, your lien is a very limited value. Do your research to make sure you understand whether or not you actually have a lien in the landlord's property or only the tenant's property. To the extent you're a sub or a supplier or a sub-sub, make sure that you limit your pay when paid risk, because if you don't have a good lien, then having a pay when paid means that you may have very little recourse, if at all, to get paid. And then send a demand for a copy of the lease, which is that form that I showed you already, because that may give you the right to lien the landlord's interest if they fail to timely respond. The lien law is very complicated. We have this free desk tool. It's called the Lien-O-Matic. If you go to lienomatic.com, put in your information, we will send you one for free. It is a little handy desk tool. You can keep it on your desk, and it helps explain the lien law from the perspective of the GC, the contractor, the subcontractor, and it also provides information related to public projects, private projects, bonded projects, Miller Act federal projects, and Florida Department of Transportation projects. All of those rules are similar but not identical, and in those differences is where we find people make mistakes. So if you get this Lien-O-Matic, it'll help you understand all of those nuances. So with that, Jesse, do we have any questions?
Well, first of all, Alex, as always, you're incredible. Thank you so much. Yes, we do have a couple of questions that came through. The first one is that it says, what happens if the landlord is holding a deposit from the tenant and we foreclose on the lease? Or if the tenant is evicted, can we make a claim on that deposit?
The answer is yes. However, having done this a long time, I will tell you almost always, not almost, every single time, the landlord will use that deposit as a first security on their right on the lease, right? So when the tenant defaults on the lease and there's a security deposit, the landlord is going to use that to offset the landlord's damages because of the tenant's default. So there's likely never any money left after the landlord pays himself all the damages that they may be entitled to.
Okay, perfect. Thank you so much. Another question that came through, it says, once the NTO is sent and the owner provides a copy of the lien prohibition that was signed but not recorded before the project, does that suffice, or must it be recorded to be legally enforceable?
So a landlord has to follow two steps. Step one is they have to have that lien prohibition in their lease. And step two is they have to record either a copy of the lease or a memorandum or short form version of the lease showing that provision in the public records. If all they do is have it in the lease but it's not recorded, then they have not met, the landlord has not met their burden to keep their property free and clear of liens.
Okay, wonderful. Thank you. And then another question that came through, it says the property is being sold to a new owner and I haven't been paid. I'm scared that the new owner will benefit from my work and the old owner will walk away. Is there anything I can do?
Assuming you have recorded a lien already prior to the sale, then assuming it's an arm's length transaction between the buyer and the seller, the buyer is going to take title subject to your lien, meaning the lien follows the property, it doesn't follow the parties, right? So if you have a lien on a piece of property and there is a sale, that sale, the buyer takes that property subject to that lien, which, by the way, is why during the course of a normal closing, the closing agent is going to want to verify that if there are any liens that they get paid at closing, because in a normal transaction you're not going to be able to get title insurance as a buyer unless all of those liens, open permits, municipal liens, open notices of commencement are all closed out. So so that's usually what happens. So you should be protected if you've recorded a lien. If you still have lien rights and you haven't recorded a lien, you should record a lien right away.
Got it. Another question that came through, it says, we have a contract with a tenant and they moved out in the middle of the night. What recourse do we have?
Probably not a lot, unfortunately. You can record a lien on, again, most likely just the leasehold interest, but then again, if they've moved out, they're probably in breach of their lease agreement, which means the landlord is going to evict them. If you have a direct contract with that party that moved out, you can still sue them for breach of contract. Again, I don't know what assets they may have, but it's not that you don't have any recourse. You do. The question is, does any of that recourse turn into green dollar bills? That's the harder question. And someone that's moving out in the middle of the night, it doesn't bode well.
Correct. Okay, and then another question that came through, it says, what happens if the lien provision is recorded, but the actual customer is the landlord? Can you lien the property?
Yes, if the landlord hires you, your lien is as to the landlord's property. So again, if we go back to my example, if I own a strip mall and it's got 15 units in it, and I hire you as the roofer to re-roof the building or do the AC work, or even if I hire you as if I as the landlord hire you to tile or reinstall floors in one of the units, your lien is going to attach to the whole property because the contract was with the landlord. The highest level contract is with the landlord, not with the tenant.
All right, perfect. I do think that was all the questions that have come through. If anyone does have another question that wasn't addressed or anything, please feel free to reach out and we'll be sure to answer any questions. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next slide, please. All right, our next webinar with Alex is going to be July 17th, so a month away. It's stop, don't sign that waiver unless it says this. And then the one after that is August 21st. How do I get paid after recording a lien? Please sign up for free at sunraynotice.com/education. We'd love to see you guys there. All right, if you guys are in the Miami area, Alex is going to be presenting alongside with Ariella for our live seminar on October 16th for Lien Waiver and Release Masterclass. So if you're interested and you're in the area, please register at sunraynotice.com/seminar. We would absolutely love to see you guys there to be able to have a really thorough conversation. If you don't mind, give us a moment to review us on Google. We really appreciate any of the feedback that you're able to provide to us. It helps us better ourselves and our content and what you're looking to hear about. All right, and then the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much to everybody that attended. We hope to see you at our next webinar. Alex, again, you're always incredible. So thank you so much. We really do appreciate it. I hope you all have a beautiful and sunny day. Thanks, everyone.